look at this bill as raping parents of their children and children of their parents. Now, John Tomicki, League of American Families.
In various capacities, we've been down here working in the legislature for almost 25 years. Having gone through many, many hearings, specifically it dealt more well with what happened in Senate Judiciary, statements would be made by individuals when the judge would come up with confirmation that were blatantly untrue. The judge might have been a public figure, therefore not protected under New York Times versus Sullivan. So slowly a process is developed, particularly relative to certain nominees coming up not being truthful on their resumes. So starting way back with Senator Gorman and before that, nominees, candidates were being put up and asked to take it off that what they were saying was true. Particular longest hearing was under former Chief Justice Williams. Having sat through the hearing and listened to what had happened, and then other research has been done by Mr. Quinlan and others, there seems to be a problem in the veracity of the testimony. I don't think it's a wise procedure to proceed on setting up a new policy, which seems to be one-sided, based upon testimony that may have been inaccurate. I said may. So by the end of the week, because as reported in one newspaper, we're busy monitoring the Gosnell trial right now. As we all know, some of we're following it, the jury is out. So by the end of the week, we're going to be, our organization will be sending out a letter to both the Senate President and the Speaker. The bill has not come up yet in the Assembly. We're asking that the bill be sent back into committee to let the testimony, whatever further new testimony, new addition, other counsels will come forward, because what was stated there, if in fact that happened, that should be the subject of immediate criminal prosecution. You don't touch people in this way. In the 3 or 4 counsels I've talked to in New Jersey, they have never heard or seen of anything like that. If it has happened, then I would help that individual to make sure that that was successfully prosecuted, not only criminally but civilly. So that in New Jersey we have a legislation pending. We understand similar legislation has just been filed in Pennsylvania. So we'd like to see a clear policy set forward. So when respecting leadership and the way the process works here, we will send a letter out at the end of the week politely suggesting that the bill be sent back into committee. Maybe a legislator will even make such a motion on the floor. We don't know. We haven't addressed that. But as was said by one of the earlier speakers here, you're looking for the truth. I've heard therapists now saying how, I call it Dr. Tara, how they approach this counseling. They're trying to do it with love and respect and help the individuals that are seeking it. We've already testified during that committee hearing that we think that there's still a problem in the legislation, that if a young girl has had a sexual encounter with a mature person, and when my example said it was a teacher, that becomes a legal problem right away. But now this young girl, age 16, let's say she is, wishes to discuss it with her parents and a counselor. We don't think the legislation, in effect, is going to prohibit that. The chairman of the committee said no. Other members of the committee, like Senator Rice, said no, he'd like to have that cleared up. So we see problems in the legislation. We think it should go back in the committee to make sure that the policies that the state would set forth would be based on accurate testimony. Thank you very much.